How do you make your own estate plan? My name is Dan Krause. I'm an estate planning and elder law attorney in Wisconsin, and I do estate planning and elder law and probate for a living. Today, I want to talk a little bit about how you can do your own estate plan if you so desire. Now, I want to start out by recommending this is what I do for a living, and I don't recommend that most people do their own estate planning. But if it is something that you want to do and you've got the time and the expertise and you're kind of smart, it is something that you can certainly do. There are some holes in most people's ability to get it all right and account for all the contingencies that might happen. But here we go. So I have a lot of people come into the office and they have documents that they've created or that they have their friend has created for them, and they wonder, is this good? Is this something that I can use? And without looking at it, I say it's probably fine. It's not something that I would produce for you. But the major documents of estate planning are, there's no secret about it. It's a will, power of attorney for finance, power of attorney for healthcare, and living will. Those are the biggies. Those are really the main ones. Married people, a lot of times, a marital property agreement is included in the basic estate planning documents. And you can find forms for all of these online. There's some places that you can buy them. There's some places that you can get some for free. And then you can modify them to meet your needs or wishes. So how do you go about doing that? Well, I would suggest that if you are intent on doing this, and many people are, I just want to also say that there are some people who are never going to pay for my services, though I think we give a lot of value, a lot more value than the amount that we charge. I understand, and I've met many people that just want to do it themselves, and in the end, that's the only way that they're going to do it. So I want to help you a little bit. Set aside probably a weekend or maybe 2 or 3 or 4 weekends that you can do just some background research on what is estate planning, what is a will good for, what are revocable living trusts, what's an irrevocable trust, what is an ILIT. It is an irrevocable life insurance trust. If you have lots of money, or if you may have a few $1 million at your death, you should probably look into those. Um, and after you've done your research, now you probably should go online and looking for some forms. Um, I'm guessing that you're not going to find the same forms that I use online. The most um, comprehensive forms are only for attorneys generally. The two subscriptions that I have to Wealth Docs and Elder Docs, or Wealth Counsel and Elder Counsel, um, they're attorney organizations. They cost several $1,000s to start, and then you pay about $500 or $600, $500 a month for each subscription in order to have access to their constantly updated forms, and it's all up to date and state of the art type of stuff. You're not going to have access to those forms, but if you've done your research well, you will be able to take the basic forms and then add in all the things that should probably be added into most estate plans. Now, if you just use the basic forms, most of the time you're going to be covered as long as you um, sign them properly. So the execution of the documents is key. Pay attention to the law. In the 850s, I can't remember what statute section in Wisconsin covers wills and how to sign them. It's in the 850s. It's pretty easy to find. But in order for a will in Wisconsin to be valid, you've got to have two witnesses, and the two witnesses have to be present at the time that the person signs. And the two witnesses basically verify that the person is who they say they are, that they are signing this and they desire it to be their will, and that they believe that the person has competence. So if you're doing a will, you want to give to whomever you want your stuff, then make sure that before you sign it, you get two disinterested witnesses together so that they can watch you sign. Now, when I say disinterested, please make sure that they are not related to you and they are not going to receive anything from you at your death. Also, you shouldn't be paying them to be a witness. That would make them interested and they could be persuaded to say that you are competent if you're not. So the presence of either paying somebody or them being a beneficiary or a family member can void your will. So be careful about that. Most of the forms that you're going to find on the internet are not going to do a good job in taking care of beneficiaries who are disabled unless you specifically find language and put it into the standard forms. Um, Supplemental needs trust as an option for somebody who is receiving assets from you. It's a good idea. Now, I know a lot of people who do planning for themselves and they have disabled beneficiaries, um, just disinherit them, which I think is a terrible idea. Those people probably need the support and the money more than others. But because they don't have the expertise to create a supplemental needs trust that can allow that person to receive financial benefits from the county or the state, and the benefits of the money that you would give them. Because they don't know how to do that, they just disinherit them uh, and feel that they are doing something good. I would advise against that. Um, there's sometimes people, another pitfall for do-it-yourselfers is thinking about all the computations of what if this person would die before me, or what if they die in the same car accident as I do? What if their kids are going to inherit? What if someone is a young person? So if I name my sister as a beneficiary and she has a young child, but she and I perish together, and now her young child would be in line for inheritance. What's going to happen with that money? Have you planned for that? Be careful and make sure that you do. If your estate is taxable. So this doesn't apply to a whole lot of people, but everybody aspires to be a millionaire or a multimillionaire. So if you play the lottery, if you think that your investments are going to be over, let's say, a couple of $1 million, you should probably have some contingencies in your estate plan for a taxable estate and what to do if your estate is taxable, because pre-planning is a lot better than having your family find out that there was no plan and now they have to pay hundreds of thousands, maybe millions in estate tax that could have been avoided with proper planning. Um, the biggest hole that I see in most people's planning is they don't really account for what's going to happen if they should need nursing care. The largest suck of money from our elders, from people who have saved their whole lives at the end of life is not taxes generally, it's the cost of care, it's the cost of long-term care. And part of today's estate planning should be to find out what is, or make a plan for what is going to happen in case you need nursing care, or in case you need home-based care, or in case you need some sort of memory care, etc. These are events, or these are things that may happen in old age that require a lot of money, a lot of resources, and these are also things that need to be paid for out of your own pocket. So that if you've made plans for what's to happen with your assets, if you've done specific planning, then many of your assets can be preserved for your for yourself, for your stability, and also possibly even passed on to your children. Whereas without planning, you'd end up spending your entire life savings doing that. So that's another pitfall to look out for, is planning in case of long-term care expenses in old age. A lot of that planning is most effective if you do it at least 5 years before you would ever need the type of care, the long-term type of care. Helps to save assets for family. It helps to provide for security in your old age. Want to say a little bit about the powers of attorney that you can find online. In Wisconsin, there is a statutory power of attorney that the legislature came up with, and you can download it online. And there's check boxes where you can initial or check for all the powers that you would give to somebody. And those work in many cases, but they do not work in cases where someone needs to plan for you if you become incapacitated and need nursing care or memory care. They are not good in that situation. They are not good for planning for your possible future incapacity. So beware of those forms. Um, you may be able to find language that you can supplement those forms with, or find a form that would allow for the type of planning that we're talking about, because the state form, even if you check all the boxes and initial all the boxes, does not allow your loved one to help you plan in case of incapacity and saving your assets in that case. So, just a few pitfalls. If you're drafting documents, review them, use these guidelines for finding holes in those documents. If you would like not to do your own documents, we can help you with that too. So please give us a call if you would like to schedule a consultation where we can talk about what kind of planning that we can do for you. The number is 608 268 5751. We are Krause Estate Planning and Elder Law Center, 608 268 5751. Thank you for your time. Good luck.